Hey guys, today's legal tip is conflicting provisions in your contract. So my friend Mark and Kelly up at Allen Tate up in Greenville reached out to me on this great question. And what they tell me is that in the state contract, and we're going to talk about it both on the state contract and on CCRA contract, that what people are doing in the state contract now they're seeing is that people select the repair provision, and then they also go and select the due diligence provision as well. And so they have a conflicting selection in the contract. And I guess you could look at it on a CCRA level as being the same thing as what happens when people are wanting to do the due diligence inspection period, but they're also by mistake selecting paragraph 10, which is as is. So we'll talk about that in a second. Before I do, don't forget to listen to my podcast this week. I'm going to put a link to it below, or you can simply go to blaircato.com, BLAIRCATO.com. and click our website, and in the upper corner there's a podcast button you can click on. Great podcast on how your brokerage and attorneys are probably screwing you in your business when they have these financial arrangements that don't benefit you, that only hurt your business. It's a great listen to. I've had so many good comments and compliments on it. People have given me horror stories of how their brokers have been pushing certain vendors based on how much money their companies are making off of it, and how they don't make anything, and it's hurting their business with poor performance and higher fees. So I think it's a great podcast for you to listen to. So what we're going to talk about first, let's look at the state contract. In the state contract, if you click both repairs and due diligence, what are we going under? Are we going under the repair provision, or are we going under the due diligence provision? This is a great lesson for everybody, that when you take the core class, and it's a wonderful core class this year because it walks through the law, one of the sections we talk about in this class that we teach through CCRA, and you can sign up for that whether you're a member of CCRA or not on our website at Blair Cato by clicking on the resource button and go into realtors. What you will find is that one thing they talk about is how do you interpret what happens when things go wrong. And one of the things you always do is you can look to the contract, see what the contract says, or you look to the statute, see what the statute says. And in this situation, the contract gives us the answer to this question. If they select both the repair addendum and the due diligence provision, which one survives? Well, it says under paragraph 8, check only one of the following options. If no boxes are checked, then the contract will be an as-is contract in regard to repairs. If multiple boxes are checked, then the first paragraph with a checked box will determine repairs. So in the situation in the upstate where they're using the state contract and the buyer selects both the repair provision and the due diligence provision, the due diligence provision has absolutely no weight or control. It defaults to the repair provision. So in the upstate, you do not get to select both of them. What Mark said is that people will select repairs because they want to have a little part, or the due diligence period, because they want to have a little section here where they can just walk for any reason. And then if they decide they don't want to walk, then they'll want to do the due diligence. Well, that just doesn't work that way. It's one or the other. The contract's clear. You look at the contract in bold letters. If you select both, then it's going to default to the repair process. Now, in the CCRA contract, not something we really have a lot of trouble with. I think most people understand that paragraph 9 is our inspections, and that's to be used, as it says, in bold letters. This is being used unless you're using as is. Or using as is, go to paragraph 10, and only with paragraph 10 would you select as is. And it does say if you select this, then no other provision, paragraph 9 does not apply. So if you wanted 9 and you do 10, your client's going to be stuck with 10, which is as is with no due diligence or as is with due diligence. So not a big factor in the CCRA contract, but in the state contract, it certainly is a big factor. They cannot select both due diligence and repair procedures. So hope that clarifies that. But the key to understanding it here is always look to the contract and see what the contract says. All right. Hope everybody has a great week. Give me some comments on what you think about the video as well as the podcast. Y'all take care.